This matter is for judgment. This is the judgment on 26th day of October 2023, when the final written addresses were adopted by Council. This matter was adjourned to 13th day of December 2023 for judgment. However, due to unforeseen circumstances that may not allow the court to sit on 13th of December 2023, I directed that the judgment should be fixed for today to be delivered virtually. By a general form of complaint dated 22nd day of July 2022 and filed on the same date at the registry of this court, the claimant claim against the defendants jointly and severally for the following reliefs. The reliefs have been reproduced in the body of judgment, so I will keep reading them. The defendants, with the leave of court, filed their statement of defense out of time, and it was deemed properly filed and served. In the joint statement of defense, they denied claimant's claim, and about that, the claimant is not entitled to any of the reliefs being sought. At the hearing of the complaint on 20th day of July 2023, the claimant testified in proof of her case as CW1. CW1, after identifying her witness statement of oath, adopted same as her evidence in this case. Documents were also tendered through CW1, which were marked as exhibit accordingly. The defendants in their proof called one Egbara Edet Basi, a staff of the Judicial Service Commission, who testified as DW1. No document was tendered through DW1. The case of the claimant, I have reproduced the facts which the claimant relied in bringing this case to court. I shall keep reading it. The defendant's case also, I have reproduced or captured the essence of the defendant's defense. I shall also keep reading it. The submissions of the defendants, Dr. Nkasi Ivo Open, Senior State Counsel 1, Ministry of Justice, who appears for the defendant, adopted the final written addresses, joint final written address of the defendants, and asked the court to dismiss the claim of the claimant. 3 issues were formulated by counsel for resolution. The 3 issues have been reproduced together with the argument. The rest of the issues canvass. Then I go to the submissions of the defendant, the claimant, sorry. The claimants Mr. Patrick O. Ariko, counsel for the claimant, formulated 3 issues for determination. The 3 issues have been reproduced. Likewise, the argument of counsel on those 3 issues have also been reproduced in the judgment of the court. I now go to the decision of the court. I have carefully and painstakingly considered the processes filed before the court, the evidence led by the parties in proof of their respective cases. Let me start by saying that the facts leading to the institution of this case are straightforward and very simple and not much in dispute. I have already stated the facts above as presented by the parties. The controversies that need to be resolved centers on the entitlement of the claimant to her claim of arrears of unpaid salaries for 27 months from February 2019 to April 2021. There is also the claim for short payment of salaries from May 2021 to December from May 2021 to March 2022. There is also the issue of whether the employment of the claimant, which took effect from 2nd day of February 2019, is still subsisting, or it is the subsequent employment of the claimant, which took effect from 17th of May 2021, that is valid as subsisting employment of the claimant. The claimant asserted that she is still an employee of the defendant based on her contract of employment of 3rd day of February 2019, which is Exhibit CWA in this case. The reason being that the said employment is one that has statutory labor, and she has not been terminated in line with the conditions of service. The dependents on their part are of the view that the claimant's employment has been cancelled by the acceptance of the contract of employment by the first defendant, and this and the also acceptance of the contract of employment, which took effect from 17th of May 2021, which supersede that of 3rd of February 2019. According to the defendants, with the acceptance of contract of 17th day of May 2021, the claimant has lost the right to make any claim in respect of the contract of 3rd day of February 2021 because parties are bound by their agreement. The claimant has insisted that her contract with the defendant is one that has statutory labor. Consequently, any cancellation or action to be taken by the defendant against the claimant has to be in line with the public service rules. The claimant heavily relied on Section 6, subsection 1 and 2 of the Magistrate Court Law in contending that his employment is one with statutory labor governed by the public service rules. The defendants have, in paragraph 1 of their statement of defense, admitted the abandonment contained in paragraph 1 to 13 of the claimant's statement of facts. With this admission, the claimant is relieved of the burden of proving what the defendant has unequivocally admitted. This also means that the parties are at idem regarding the abandonment contained in paragraph 1 to 13 of the claimant's statement of facts. The law is well settled that facts admitted need no proof or need no further proof. See the case of CBN versus Dine, reported in 2021 to 15 NWLR Part 1798, page 91, where it was held that an admitted fact requires no further proof. It is deemed established. Thus, when an allegation of material nature is taken as admitted, there would be no need to adduce further evidence to prove the allegation. See the case of Judicial International versus Diamond Bank. The position is strengthened by the fact that parties are bound by their pleadings, and the defendants having admitted paragraphs 1 to 13, they are bound by the abandonment. See Cardoso versus Doherty. See also Adewoye versus Adewoye. No party will be allowed to depart from the admission of paragraph 1 to 13 of the statement of facts by the defendants in their paragraph 2 of the statement of defense means that they have accepted the abandonment therein as the true facts. They have also authenticated the claim of the claimant that she was employed by the third defendant as senior magistrate court grade 1 on salary grade level 14, and that she has undergone training and posted to a place of primary assignment for adjudication. The defendant, despite the admission of paragraph 1 to 13 of the statement of fact, proceeded by Exhibit 67 by paragraph 678 of the statement of defense to set up a different the claimant was by the exhibit CWA letter of appointment appointed senior magistrate grade level 1 proceeded from 3rd of May 2019. The defendants have admitted the claimant's appointment evidenced by exhibit CWA. There is also evidence that the claimant assumed duty in furtherance of the appointment made as per exhibit CWA. After undergoing training and orientation for newly appointed magistrate at National Judicial Institute Abuja, the claimant was posted to Calabar Multi-Door Court as Senior Magistrate 1, wherein she performed her duties. However, the claimant was not paid any salary after assumption of duty by the performing by when the claimant and her other colleagues could not bear the excruciating effect of non-payment of their 27-month salaries, they embark on peaceful protest in an attempt to forestall embarrassment being caused by the protest. The then acting chief judge of Cross River State by the exhibit CWG instructed the claimant and her colleagues to suspend sitting until the issue of non-payment of their salaries are resolved. Instead of claimant being paid her unpaid 27-month salaries, a new letter of engagement was presented to the claimant. According to the claimant, she accepted the new offer under duress and based on the understanding that her 27-month salaries would be paid to her upon her acceptance of the new offer of employment. However, the defendant refused and paid to pay her 27-month arrears of salaries and paid arrears of salary. With the evidence before the court, the defendant have admitted not paying the claimant her 27-month salaries. The non-payment of 27-month salaries of the claimant was attributed to the cancellation of the recruitment exercise that culminated in the appointment of the claimant by the first defendant. The defendant have also, through their pleadings and witness statement on oath, stated that the newly constituted Judicial Service Commission reviewed the cancelled employment of the claimant and made special appeal to the first defendant through the second defendant for fresh appointment of the claimant and 28 others. With the appeal, the first defendant obliged. In the consequences thereof, offer of appointment letters were issued to the claimant and 28 other magistrates, and the claimant voluntarily accepted the new offer of appointment by signing the acceptance, based on which letter of appointment dated 26/5/2021 was issued. Now, taking into consideration the provisions of the Constitution establishing the third defendant and those conferring power on the third defendant to appoint a magistrate, it will be right to say that the first defendant have the requisite power, has no requisite power to or direct cancellation of any appointment made by the said defendant in the exercise of its constitutional power. The answer is simple. The case defendant does not have power to interfere with the constitutional exercise of the function of the said defendant. This is the thrust of the essence of the constitutional provision as provided in Section 202 of the Constitution as amended. Section 202 provide in exercising its power to make appointment or to exercise disciplinary control over persons, the State Civil Service Commission, the State Judicial Service Commission must the above quoted provisions of Section 202 of the Constitution as amended is very clear and unambiguous that no authority or person is allowed to interfere with the exercise of the powers of the said defendant or direct its affairs. The said defendant in this case is one of the independent executive bodies established by the Constitution of the Federal Republic of Nigeria as amended. The Constitution has established the said defendant and made it to be free from any control or interference in carrying out its function. Constitutional function. Therefore, the cancellation of the appointment of the claimant cannot stand, having been made on the instruction of the first defendant. The said defendant, in acceding to the request or direction of the first defendant, the Constitution having prohibited the interference of the said cancellation is null and void and of no effect whatsoever. It was done in contravention of the law. In XBCWA, no reason was given for the purported cancellation of the claimant's appointment made as per XBB. The cancellation of the claimant's appointment by XBCWA since act of misconduct on part of the claimant, and for any action to be taken on misconduct, the claimant deserves to be notified or informed of the acts of misconduct against her, which will lead to cancellation of her appointment. It is not only the information, she must be tried for misconduct and found guilty before such drastic action can be taken or meted on her. There is no evidence adduced by the defendant to show that the claimant was ever accused of any misconduct or even tried and found guilty to warrant cancellation of the appointment. The appointment of the claimant being one that has support from the Constitution and statute cannot be wished away at the whims and caprices of a third party or even the third defendant. The said appointment cannot be tampered with without following due process. The appointment of the claimant having not been made at the pleasure of the first or third defendant, and four, the absence of any reason for cancellation of claimant's appointment goes to support the assertion that the cancellation was not made for any act of misconduct. Rather, it was done in carrying out the directives of the first defendant. The new appointment as per XBCWE was also as a result of the approval of the first defendant. All this goes to show that the first defendant's action is clear usurpation of the power of the third defendant, which the provisions of Section 202 of the Constitution set out to protect. The facts of this case clearly shows interposing in the function that is clearly not the business of the first dependent. This is clearly executive meddlesome in the affairs of the judiciary, which should be deprecated. In the case of Hart versus military governor of Kaduna State, this is clearly executive meddlesome in the affairs of the judiciary, which should be deprecated. In the case of Hart versus military governor of River State, the highest court of the land did not only frown at such kind of interference by executive in the affairs of the independent bodies, but viewed such frightening stance rather than with frightening stance. The apex court set aside the order of military governor in Hart versus military governor of River State, even when it was clear that the military governor did not deliberately intrude, but was invited into the fray by the Public Service Commission of River State itself without any prompting from the governor. It is without any doubt that Section 202 of the 1999 Constitution as amended grant absolute independence to the third dependent in the manner of employment and discipline of its employees. Since in this wise, the very proceedings of third dependent In this wise, the very proceeding of the third dependent Judicial Service Commission regarding the claimant are prejudicial and jaundiced by virtue of the concurrent external interference of the first dependent as the third dependent carried out instruction or directives of the first dependent. Therefore, the cancellation is liable to be set aside for perverting the course of justice being a product of outside dictation. The situation in the instant case is somewhat similar in its essential aspect of that of Nawa versus Attorney General of Cross River State, wherein the governor of Cross River State unilaterally retired the plaintiff's appellant without resort to all the legal effect of interference of the governor of Cross River State in Nawa's case is same with the instruction or directive of the governor of Cross River State for cancellation of the claimant's appointment as per Exhibit DWE. The legal effect is one and the act of cancellation of the claimant's appointment and unilaterally appointing her to the lower grade level without any hearing is also ultra-bias the powers of the defendant. What happens to first dependent? The first dependent uses the third dependent to perpetuate illegality. In Nawa's case, the plaintiff in the instant case, since it is the order of the first dependent that the third dependent merely carried out, the new appointment and cancellation of claimant's appointment as per Exhibit CWE are vitiated and liable to be set aside. As no, the claimant has also stated that the second contract of employment was executed under duress. In response to the defendant's statement of facts shows that the new appointment magistrate grade 2 was not under any coercion, nor was claimant under any compulsion to accept the said offer, as she had unfettered option to either accept or reject. It is also the case of the defendant that claimant did not only accept her new appointment but proceeded in collecting salaries and continued to perform her duties under the new contract. It was also stated that the claimant, by willingly entering into the contract of employment with said dependent in April 2021, has waived her right and entitlement under the provisions of appointment. In her leadings and evidence before the court, the claimant stated that the acceptance of appointment as per the CWE, which was a lower grade level, to the grade level she was first appointed, was under duress. In proving her allegation of duress, the claimant pleaded particulars of the duress in paragraph 24 and 25 of the statement of facts and witness statement on oath. From these paragraphs of the statement of facts, it is clear to me that the claimant was pressurized to accept the contract of service, which pleaded her to on a lower rank that is not commensurate with her qualification and experience. Due to financial constraint with the non-payment of 27 months' salaries, the claimant was forced to accept whatever offer that came across her in order to be able to survive. I find that the claimant was coerced into accepting its BC, into accepting its CWE. The acceptance was not free from pressure, nor was it voluntary. It was done due to no other option as a result of financial pressures. I quite agree with the counsel for the claimant that the duration of the contract I quite agree with the counsel for the claimant that duress need not to be physical, it may be otherwise or financial, as in this case. See Calabar Central Cooperative Thrift and Credit Society and others versus ECO. See also FCMB PLC versus Penbook Limited. The counsel for the defendants has also strenuously argued that the claimant, by signing or accepting the offer of appointment of 17th day of May 2021, has destroyed or lost her claim of 27 months salaries, which the appointment of 17th May 2021 has cancelled. Exhibit CWE which in paragraph 2 cancels the earlier appointment of 3rd day of February 2019. In the circumstances, having found Exhibit CWA not to have been properly issued, and in view of the fact that the first dependent does not have the bias to cancel XBCWA, I hereby found that the XBCWA is still subsisting, is still valid and subsisting, and it is what governs. It is the appointment. It is what established the appointment of the claimant, not XBCWA, which was not issued in accordance with due process of law. The law as per earned entitlement is that an employee is entitled to all her earning prior to dismissal, termination, or removal or cancellation of appointment. See Idigbe versus FCDA. See also Underwater Engineering Company Limited versus Dubicom. See also Kasali versus Kasali Olubinga versus Access Bank PLC. It is clear from these cases that when an employee lost his employment, his earned entitlement remains sacrosanct. It is also cardinal principle of law, labor jurisprudence, that an employee cannot be subjected to a retrospective policy as to deny him a benefit. See Ikioma Aja versus Fidelity Bank. Applying the principle of law enunciated in the above case law, the defendants would not be allowed to unilaterally cancel employment of claimants and demote her so as to deprive her of her earning. That is the salary she earned from 3rd of February 2019 to April 2021, when the new letter of employment XBCWE was issued to the claimant. Subsequent letter of appointment XBCWE had been issued when XBCWA was in existence, cannot affect the status of the employment of the claimant when the claimant has even protested against the action of the third dependent. See XBCWF. XBCWE, having placed the claimant on a lesser grade level, amount to demolition and demotion, XBCWE, having placed the claimant on a lesser grade level, amount to demotion, and demotion is one of the punishments as punishment an employer can enforce on his employee as a result of disciplinary action. The defendants, having not tried the claimant, do not have the power to unilaterally demote the claimant, or as demotion has to be product of disciplinary action. Since there is no disciplinary action against the claimant, XBCWE cannot be allowed cannot be allowed From all I have been saying above, the claimants having shown that she was duly employed as a senior magistrate, grade level 14, and has worked for 27 months without pay, she is entitled to be paid her earned salaries. It is to be noted that claimants have admitted employing the claimant as per XBCWA. They have also admitted she worked for 27 months without being paid salaries. The only reason given for not paying claimants 27 month salaries was cancellation of our employment as per XBCWE, having found that XB It is to be noted that the claimant having admitted employing claimant as per XBCWA, they have also admitted she worked for 27 months without being paid. The only reason given for not paying 27 months was cancellation by employment as per XBCWA. Having found XBCWA null and void and cannot coexist with XBCWA, the claimant's employment has not been cancelled and she is entitled to her unpaid 27 month salary. On the balance of unpaid salaries from May 2021 to date, having found that the defendants have no power to demote the claimant, she is entitled to be paid balance of salaries from May 20. The defendants have also raised issue of leches and acquiescence to defeat the claim of the claimant. These are special defenses that refers to slackness and unreasonable delay or negligence in pursuing a right or claim in a way that prejudices the party against whom relief is sought. Acquiescence, like laches, is a person's tacit or passive acceptance or implied consent to act. Being equitable defenses, they must be considered based on the particular facts of the case under consideration. However, account is taken of the actions and behavior of the claimant and the defendant, and sometimes the impact on third parties. There are certain factors to be taken into consideration. See Tayo versus Tayo, where see also Kayode Odutola in Odutola versus Ibadan City Council, Patai Williams, JSC, as he then was, stated that a plaintiff faced with the defense of leches and acquiescence may succeed in his claim if he can make a reasonable explanation for the cause of delay to assert his right. Such explanation may be one, that he was all the while ignorant of his right, or that he lacked full knowledge of the existence of such rights, or two, that he was all the while under legal disability or incapacity, or three, that he was under undue influence, or that he lacked free will. The claimant has, in response to the equitable defenses of leches and acquiescence raised by the defendant, put up the defendant's argument. The claimant has stated that she was not indolent and never rested in her pursuit of her right, as she had protested and also wrote to the defendants for payment of her entitlement. See Exhibits H, J, K, and L. It was also argued by counsel on behalf of the claimant that there is necessity for the defendant to plead equitable defenses. I quite agree with counsel for the claimant that final written addresses is not the appropriate forum for putting up defenses of laches and acquiescence. These are special defenses that the law requires defendant to specifically plead them in their statement of defense. Having not done so, they must fail as they were not appropriately raised. See the case of Adeniran versus Alao. See Anyaora versus Anyaora. See also Alabi versus Dohati. One other vital issue to be considered is party raising the equitable defense must have clean hands. This is one of the cherished maxim of equity, that he that comes to equity must come with clean hands. See the case of DPCC Limited versus DPC Limited. See also Elau Bachi versus Phillips. See also Apolabi versus Wood and Shuru. And Anima Shaun versus Bakare. The question to be asked here is, can the defendants in this case be said to have come to equity with clean hands in raising the equitable defenses, having regard to the facts as disclosed by the pleadings and evidence before the court? There is no doubt that the defendants, having denied the claimant 27 months salaries after it was also argued by counsel on behalf of the claimant that there is necessity for defendant to plead the equitable. I quite agree with the counsel. Having not done so, the defenses must fail as they were not properly before the court. See Adeniran versus Alawe. See Anyora versus Anyora. On the issue of coming to equity with clean hands, having regard to the facts as disclosed by the pleadings and evidence before the court, there is no doubt that the defendants, having denied the claimant 27 months salary after having worked and earned same, cannot be said to have clean hands. They are guilty of wrongdoing, i.e. denial of claimant her salaries for 27 months. Therefore, it will be unconscionable to allow the defendant to raise the equitable defenses they are attempting to raise. The law is well settled that it is to be noted that the claimant in this case has been able to put good resistance to the plea of laches and acquittances by the defendant. This is because the claimant has been able to show that the second contract of employment was due to undue influence, and the defendants have not been able to properly raise equitable defenses they are relying on to defeat the claimant's action. And even if they have properly raised the defenses, they have not come to equity with clean hands. From the foregoing, the claimant has proved entitlement to some of the reliefs being sought before the court. In view of the foregoing, it is hereby ordered as follows. A declaration is hereby granted that the employment of the claimant as Senior Magistrate Court 1, salary grade level 14, in the Cross River State Judiciary with effect from 2nd day of February 2019 is valid and subsisting. 2. A declaration is hereby granted that the said defendant purported cancellation of the claimant's appointment of 3rd February 2019 as senior magistrate grade 1 level 14 in Cross River State Judiciary, and the purported reappointment of the claimant by the said defendant as magistrate grade 2 on grade level 10 in the Cross River State. A declaration is hereby granted that the said defendant purported cancellation of the claimant appointment of 3rd February as senior magistrate grade level 14 and the appointment of the claimant by the 13 as magistrate court is a declaration is hereby granted that the claimant is entitled to salaries and emolument due to other magistrates in Cross River State on the same rank and salary grade level, which claimant was appointed with effect from 3rd of February 2019. That is salary grade level 14. The declaration is also hereby granted. The defendants, are hereby ordered to pay the claimant the sum of 10,328,103 naira 52 kobo, being unpaid arrears of claimant salaries from months of February 2019 to May 2020 to March 2020. 2. The defendants are hereby ordered to forthwith pay claimant salaries as senior magistrate grade level 14, having nullified the cancellation by the defendants, cancellation of the claimant's appointment as per XBCWE and upholding the subsistence of XBCWA. It will be an academic exercise to order the designation of employment of the claimant, since the original appointment of the claimant has been restored. On general damages, having granted the claimant's salaries, it will also amount to double compensation to grant that relief. In the circumstances, the relief for general damages is refused. However, the defendants are hereby ordered to pay claimants the sum of 300,000 naira as cost. This is the judgment of the court, and it takes immediate effect.
As the court
Hello. May I announce my
Related appearance.
Yes.
Yes. My Lord,
yes.
for the
Two of you
defendant.
cannot talk at the same time. It has to be one after the other. The claimant counsel. The claimant counsel. The claimant counsel. It appears he is not hearing me.
I believe so because it's online.
Hey, he's online, but he's not responding.
Maybe
Yes,
it's
Mr. The dependent counsel.
Yes, my lord. May I announce my related appearance? My lord.
My name is Nkasi.
Yes.
Often I appear for the defendant.
The defendant.
It's all right.
Thank
you.
Taking and
Yes, registrar, call the next case.
Yes, my lord. Case number NIC 32/2022 between Agnes and Thomas Akomaye Esquire and one government of Cross River State to the Attorney General and Commissioner for Justice, Cross River State. 3. Cross River State Judicial Service Commission. My lord, the parties are all absent.
Yes, appearance. Appearance. Yes, appearance.
The Lord, Dr. N.I. Offem, State Council 1.
Yes.
Lord, appearance.
It appears the claimant counsel has gone offline. This matter is for judgment. The judgment will be read shortly. It will be read virtually. This is the judgment of the court. On 26th day of October 2023, one final written addresses were adopted by counsel for both parties. This case was adjourned to 13th day of December 2023 for judgment. However, due to unforeseen circumstances that may not allow the court to sit on 13th day of December 2023, I directed the forwarding of the date whereby I fixed the judgment to be delivered today. By the general form of complaint dated 25th day of May 2022 and filed on the same date, accompanied by statement of facts, witness statement on oath of the claimant, list of witnesses, list of documents, and photocopies of documents to be relied on at the trial. The claimant's claims praise for the following reliefs. I have reproduced the reliefs, so I shall skip reading them. And upon being served with the originating processes, commencing this with the defendants on 20th day of May, on 20th day of September 2022, filed their statement of defense out of time, which was deemed properly filed and served by order of the court made on 1st February 2023. The statement of defense was also deemed as properly filed and served on the first day of February 2023. Upon due any issues, trial of this case commenced on the 1st of February 2023, where the claimant testified as CW1 after adopting her witness statement of oath tendered some documents which were marked as Exhibit A to N. One Igbara Edet Basi testified the head of human resources of the third defendant testified as DW1 in defense of the defendants. DW1, after identifying his witness statement on oath, adopted it as his evidence in this case. The case of the claimant, I have reproduced the case of the claimant. I shall keep reading it. Likewise, the case of the defendant, I have also reproduced the argument or submissions of counsel for the defendant on the three issues formulated. I have also reproduced the argument of the counsel for the claimant on the three issues formulated for determination. I therefore go straight to the decision of the court. Yes, I have carefully considered the pleadings, the evidence laid by the parties, as well as the written and oral submissions of counsel. Looking at the facts and circumstances of this case, the issues that need to be resolved is whether by the evidence adduced before the court, the claimant is entitled to any of the reliefs sought. There are 9 reliefs being sought by the claimant. 4 are declarations, and the other 5 are for either payment of arrears of salaries or shortfall of salaries and other orders and general damages. Let me say that the facts of this case are straightforward and not in dispute. The facts that necessitated filing of this suit are that sequel to the rigorous recruitment process conducted by the third defendant in July 2019 by the Exhibit B, the third defendant appointed the claimant as Chief Magistrate Grade Level 1 on salary grade level 16 with effect from 3rd of February 2019. After taking oath of office, claimant was posted for her primary assignment. The claimant was by the Exhibit G posted as Chief Magistrate Court 6, Akaipa, Calabar. Upon resumption of duty, she performs her duties diligently. On the 14th of January 2021, the acting chief judge of Cross River State invited the claimant together with other magistrates for a meeting where he instructed them to stop sitting in their respective court until their salaries are paid. He also directed the directive should be contained in Exhibit D. After the second street demonstration, the third defendant invited the claimant and other 28 magistrates in April 2021 to sign acceptance of offer of appointment to a lesser grade level. However, they refused, but they were threatened and they signed the said contract of employment under duress. The defendants have admitted employment the claimant as per Exhibit B. They have also admitted not paying claimant 27 months salaries. The excuse the defendant gave for non-payment of 27 months salaries of the claimant is that the appointment has been cancelled by the first defendant and that on assumption of duty, the third defendant reviewed the said appointment and made recommendations to the first defendant who obliged and approved appointment of their claimant to salary grade level 10. This is contrary to the admission of the claimant as admission of paragraphs 1 to 13 of the claimant's statement of facts, as the defendants have in paragraph 2 have admitted paragraph 2 of the statement on oath. And the law is that whatever was admitted need no further proof. See the case of CBN versus Dine, see Judicial International Limited versus Diamond Bank. Hence, there is no need to call evidence in support of the employment of the claimant, since it has been admitted by the defendant. The position of the law is that parties are bound by their pleadings. The defendants having admitted paragraphs 1 to 13 of the statement of facts, they are bound by it, and they shall continue to be guided by it. See Cardoso versus Doherty, see Adewoye versus Adewoye. The submissions of paragraph 1 to 13 of the statement of facts by the defendants in their paragraph 2 of the statement of defense means that they have accepted and omitted it also means that they have authenticated the claim of the claimant that she was employed by the third defendant as Chief Magistrate, grade 1 on grade level 16. And she has also undergone training and she has been posted for primary assignment. However, there is now a sudden bolster case by the defendant on the employment of the claimant as to whittle down the admission of the appointment of the claimant. Thus, when an allegation of material nature according to the defendants, the claimant having accepted a lower grade level cannot be had to object to the appointment, to her appointment, since she has accepted same. She has accepted subsequent appointment, which cancelled the first appointment. This means she has waived her right to complain or even got paid for the services which she had already rendered. However, apart from XBC, the defendants have not adduced any evidence to establish the cancellation of the claimant's appointment, which they have admitted as per their pleadings in paragraph 2 of their statement of defense. Exhibit C, which the defendant are relying, cannot be proof of cancellation, since they allege the cancellation was done by the first defendant. Now, Section 197(1) of the Constitution of the Federal Republic of Nigeria, as amended, now, Section 197 of the Constitution of the Federal Republic of Nigeria, as amended, establishes the third defendant in this suit, and by Section 6 of Part 2 of the third schedule to the Constitution, and Section 6(1) of Magistrate Court Law of Cross River State, the third defendant is empowered to appoint, dismiss, and exercise disciplinary control over magistrate in Cross River State and other staff of the third defendant. The claimant was by the Exhibit B letter of appointment appointed as Chief Magistrate Grade Level 1, Grade Level 16. The appointment took effect from 3rd of February 2019. The facts of appointment of the claimant as per Exhibit the dependents have admitted not paying the 27-month salaries, but only relied on cancellation to deny the claimant of her salaries. When the claimant and her other colleagues could not bear the excruciating effect of non-payment, they embarked on a peaceful protest, and in an attempt to forestall embarrassment being caused by the protest, the then acting Chief Judge of Cross River State by the Exhibit D instructed the claimant and her colleagues to suspend the strike and to suspend sitting until their salaries are paid. According to the claimant, she accepted the new offer under duress and based on understanding that her 27-month salary will be paid. But however, those salaries were never paid, and no the dependents have also, through their pleadings and evidence before the court, that the review of the claimant's employment was undertaken by that third dependent, and the approval for the second appointment was given by the first dependent. Now, taking into consideration the provisions of the Constitution establishing the third dependent and those empowering or conferring on the third dependent to appoint magistrate, will it be right to say that the first dependent have the requisite power to direct cancellation of any appointment made by the third dependent in the exercise of the jurisdictional powers? The answer is simple. The answer is simple that the first defendant does not have the power to interfere with the constitutional exercise of the function of the third defendant. This is the first essence of the constitutional provision as contained in Section 202 of the Constitution. The Federal Republic of Nigeria, as amended. This provision is very clear and unambiguous, and it does not allow interference with the exercise of the powers of the third defendant or directs its affairs. The third defendant in this case is one of the independent executive bodies established by the Constitution of the Federal Republic of Nigeria, 99 as amended. The Constitution has established the third defendant and made it to be free from any control interference in carrying out its constitutional mandate. Therefore, the cancellation of appointment of the claimant cannot stand, having been made on the instruction of the first defendant. The third defendant, in acceding to the request of the first defendant to cancel the claimant's appointment made as per Exhibit C, acted in abdication of her duties. The Constitution, having prohibited such interference with the said cancellation, is null and void and of no effect whatsoever, as it was done in contravention of the law. In Exhibit C, no reason was given for the purported cancellation of the claimant appointment made as per Exhibit B. The cancellation of the claimant's employment as per Exhibit C evinces an act of misconduct on part of the claimant, and for any action to be tried, the appointment of the claimant being one that has support from the Constitution and statute cannot be wished away at the whims and caprices of a third party. The said appointment cannot be tampered with except following due process. The appointment of the claimant having not been made at the pleasure of the first or third defendant, for any action to be taken, it must be sanctioned by law. Otherwise, it will be in futility. The absence of any reason for cancellation of claimant's appointment goes to support the assumption that the cancellation was not made for any act of misconduct. Rather, it was done the absence of any reason for the cancellation of claimant's appointment goes to support the presumption that the cancellation was not made for any act of misconduct. Rather, it was done in carrying out the directives of first defendant and second defendant. As per NDBC, counsel also the absence of any reason for cancellation of claimant appointment goes to support the assumption that the cancellation was not made for any act of misconduct. Rather, it was made in carrying out the directives of the first defendant. The new appointment as per HBC was also as a result of the agreement. The facts of this case clearly shows interposition in function that is clearly not the business of the first defendant. This is clearly executive meddlesome in the affairs of the judiciary, which should be deprecated. In the case of Hart versus Ministry of Governors, Benin State, the highest court of the land did not only It is without any doubt that the Section 202 of the Constitution grants absolute independence to such defendant. The situation in the instant case is somehow similar in essential respect to the case of Nawa versus Attorney General of Cross River State, wherein the governor of Cross River State unilaterally retired the plaintiff's applicant without resort to the Public Service Commission. The legal effect of interference of governor into the Cross River State civil service in our case is same with instruction or directive governing the class of action. The legal effect of interference of the governor in Nawa's case is same with is similar to the interference in the present case. Although in the case at hand, it was not done directly, but on instruction given to the third defendant, while in Nawa's case, it was done directly. The act of cancellation of claimant appointment unilaterally the appointment and cancellation of claimant appointment as per IGBC are vitiated and liable to be set aside, as nobody appointment or cancellation could be sustained. The law is that unilateral termination of contract of employment does not terminate the contract. See Opoilo versus NEPA PLC so far. The claimant has also stated that the second contract of employment was executed under duress. A response to the defendant stated that the claimant acceptance of the new letter of appointment as which he voluntarily accepts means that that contract is the one that is subsisting as it was entered into without any duress. In her pleadings and evidence before the court, the claimant stated that the acceptance of appointment as per XBC, which was a lower grade level to grade level, she was first appointed was due to and was under duress. In proving her allegation of duress, the claimants gave the particulars of the duress in paragraphs 24 and 25 of the statement of facts and witness statement on oath, respectively. From these paragraphs of the statement of facts, it is clear to me that the claimant was pressurized to accept the contract of service, which placed her on lower rank. That is not commensurate with her qualification and experience. With non-payment of 27 salaries, the claimant was forced to accept whatever offer that come across her in order to be able to survive. I find that the claimant was coerced into accepting HBC I quite agree with counsel for the claimant that duress need not to be physical. It may be otherwise or financial, as in this case. See the case of Calabar Central Operative Sirius Society versus Sirius Society and others versus EFCO. See also FCMB versus Benbok Limited. The Council for the Defendant has strenuously argued that the claimant, by signing acceptance of offer of appointment, has destroyed the argument of counsel for the defendant seems to be oblivious of the fact that the claimant in payment of arrears of 7 months salaries was a claim for an entitlement which cannot be unilaterally cancelled by the defendant. The claim of arrears of unpaid salaries being an entitlement cannot be affected by any purported cancellation of contract of employment based on which the entitlement was earned. The Supreme Court has made it very clear that an employee whose contract of employment has been terminated, dismissed, retains the right to claim all on the laches and acquiescence. These are special defenses that can be raised by a defendant to defeat a claimant's action. However, each case must be treated based on its own facts. And that a claimant that is able to proper explanation will be in a position to sustain his claim, and the defenses will see Odutola versus Ibadan City Council. The claimant has the response to the equitable defenses put by the defendant, argued that the claimant was not indolent and never relented in her pursuit of her right, as she has protested and wrote letters to the defendant, see Exhibit H, J, K, and L. It was also argued by counsel on behalf of the claimant that there is no necessity for the defendant to plead equitable defenses. I quite agree with counsel for the claimant It was argued by counsel on behalf of the claimant that there is necessity for the defendant to plead equitable defenses and not in the final written address. These special defenses must be pleaded, and if not pleaded, must fail. Counsel see Adeniran versus Salao and Enyaro versus Sanyaro, Aladi versus Johati. One other vital issue to be considered is party raising the issue must have clean hands. This is one of the cherished maxim, equitable maxim, that he who comes to equity must come with clean hand. In the present case, can it be said that the defendants are with clean hands? See SPDC versus BPC Limited. See also Elabuchi versus Philip. See also Afolabi versus Ruda Shuru. The question, whether the claimants have come with clean hand. The answer to it is very simple, that the claimant in this, the defendant in this suit, having refused to pay the claimant for 27 months, cannot be said to have clean hands. The denial, as they denied the claimant a legitimate earning, they cannot be said to be with clean hand, and they cannot be allowed to benefit from their own wrong. See Umaru versus Farm. It is to be noted that the claimant in this case has been able to put good resistance to the plea of laches and accusations by the defendant. This is because the claimant has been able to show that the second contract of employment was due to undue influence, and the defendants have not been also properly plead. It is to be noted that the claimant in this case has been able to put good resistance to the laches and accusations raised by the defendant. This is because claimant has been able to show that the second contract of employment was due to undue influence, and that the defendants have not been able to properly raise the equitable defenses as they are supposed to. And even if they have been properly raised, the defenses, even if the defenses have been properly raised, they have not come to equity with clean hand. Therefore, they cannot be allowed to benefit from their own wrongs. From the foregoing analysis, the claimant has been able to prove entitlement to some of the relief sought. In view of the foregoing, it is hereby ordered as follows. A declaration is hereby granted that the employment of the claimant as Chief Magistrate grade level 1, salary grade level 16 in the Cross River State Judiciary was effective from 3rd February is valid and subsisting. B, a declaration is hereby granted that the third defendant purported cancellation of claimant's employment of 3rd day of February as Chief Magistrate grade level 16 in the Cross River State Judiciary, and the purported reappointment of claimant on grade level 10 is unlawful, null and void, and of no effect whatsoever. The declaration is also hereby granted that the claimant is entitled to the salaries and emolument due to the other magistrates in the Cross River State Judiciary on the same rank as grade level. The defendants are also hereby ordered to pay claimant the sum of 13,461,174 naira 16 kobo, being arrears of salaries and shortfall. The defendants are hereby ordered to henceforth pay claimant salaries as Chief Magistrate grade level 16. Having nullified the cancellation of the claimant's employment, there is no need to make an order for the designation of the claimant's employment as his initial employment has been upheld as subsisting, and the appropriate contract of employment between the claimant and the defendant. The dependents the claimant, is also not entitled to any general damages because arrears of salaries and shortfall has been granted. To grant general damages, it will amount to double compensation. The dependents are also hereby ordered to pay the claimant the sum of 300 naira as cost of this action. This judgment shall take immediate effect. Judgment is entered accordingly.
As the court pleases.
Is any other matter?
No, my lord, that's all for today, my lord.
Okay, thank you very much. We come to the end of today's sitting. The administrator, you can go ahead and discontinue with the sitting. Thank you. Have a nice day.
And you too, my lord. Thank you, my lord.
Okay, bye.
We will. Is it Happy Christmas?